Hi everybody, my name is Ian Wu. I'm an attorney at Goyette, Ruano, and Thompson. I work in the estate planning department. We're located in Sacramento County, and today I've got a really interesting and great topic for you guys. It's going to be estate planning mistakes that we see from some celebrities that are known so well in their industries, whether it be music, whether it be film. We're going to be going through what happened, what went wrong with these celebrity estate plans, and what we can learn from them. As always, like and subscribe because we've got plenty of other new topics coming your way, and I want to make sure that you're in on all of them. Our first case study is going to be a pop icon. Now, many of you are probably familiar with Prince. Well, Prince passed away in April 21st of 2016, and he passed away with an estate worth over $150 million. But many people are very surprised to learn that Prince died without any estate planning done whatsoever. So he passed away with what we call being intestate. That means that his estate goes to probate, and that means that the state determines who his beneficiaries are. When the court was deciding who are his beneficiaries, well, they had to go through his family line, and it turns out that he had no spouse, he had no children that they were aware of, no parents, so most of his estate went to half-siblings that he may or have not really been in contact with. Now, knowing Prince, he likely had a very close-knit group of people that he trusted, but none of that money went to them, and his estate took 6 years to finalize in probate because they had to have all these people come out of the woodwork to determine who's going to get what. Now, the big question is, was that what he would have wanted? I think Prince maybe would have had other plans had he had taken the time to do some estate planning. Maybe he would have given some stuff to charity. Maybe he would have given stuff away to some people that he trusted, that supported him through his music career, but that's not the case. So what's our takeaway from Prince's lack of an estate plan? Well, the idea is have one, right? If you've got assets and you want somebody to benefit from them, then it's best to always put a comprehensive estate plan together to determine who's going to get what, because if you don't, then the probate court will decide who's going to get it for you. If you think that's interesting, if you like to hear about the celebrity estate planning, then please like and subscribe. We've got plenty of other really cool topics coming your way. We're happy to share them with you. Our next case study, we're going to be talking about a very famous actor who tragically passed away in 2008. Heath Ledger was an amazing actor. What went wrong with Heath Ledger's estate plan? So Heath Ledger had a will, right? He did some estate planning and he named beneficiaries in his will. But the big issue was that Heath Ledger had a daughter named Matilda, and after having Matilda, he never updated his will to include Matilda. So the problem there is that it's more likely than not that Heath Ledger, having a new daughter, would have wanted to provide for Matilda, but in his estate plan, since it hadn't been updated, there were no provisions made for her. Now, luckily for Heath Ledger's situation, his family kind of came together and they decided to contribute some of the assets to Matilda's care, which is probably what Heath would have wanted. The key takeaway from Heath Ledger's situation is major life changes happen, and you want to make sure that your estate plan reflects your current situation, reflects these changes. So having children, getting married, somebody that you know maybe passes away and might be listed there, you want to make sure that you update your estate plan with those current terms so that everything aligns with your current intentions. So number three, we're talking about our number three celebrity here, and many of you might know this famous musician. It's Tom Petty. Now, Tom Petty passed away in 2017. His trust was pretty lengthy. I think it amounted to about 77 pages. So it's a pretty sizable trust. So the issue with Tom Petty's trust was there was some language in that was a bit ambiguous, meaning that it was a little bit hard to navigate around. It was a little bit hard to understand. So what Tom Petty did was he left an enormous musical legacy, rights over his image, rights over his music, and he gave his widow and his two daughters equal rights. He gave them equal participation rights, and that really wasn't spelled out what equal rights mean. So there was a bit of argument back and forth. Does that mean that there's 3 votes, 2 being the majority? Because then the daughters always win. So this led to problems. It led to litigation. It led to determining, hey, can we use Tom Petty's name and image for salad dressing brands? We don't really know what limitations he would have wanted to set on what equal participation means because it wasn't spelled out in his trust. So what's our lesson today? It's you want to make sure that your trust language is clear. You want to make sure that if you want to limit somebody's ability to do something or somebody's rights or responsibilities under that trust, that you spell that out specifically in the trust language itself. So now we're moving on to number 4. Who's our number 4 celebrity? Number 4 is going to be Whitney Houston. Many of you know Whitney Houston, but not many people know that when she passed away, she left a will. That will left everything to her sole daughter, Bobby, who didn't take under the will right away because she was supposed to take under this will at 21 years old. But there were some issues with this. There were not any provisions placed in there to manage that money for Bobby. So Bobby did get that money at 21, but tragically she died only a few years later. So many people often say, well, I would like my kids to get everything outright when they hit a certain age, right? But sometimes situations dictate that maybe the kid isn't ready to receive all that money. Maybe they might not be the most responsible with that money. The correct thing to do in a situation is to make sure that there is a safeguard, there's somebody in charge of that money, so that the child's interest is protected, so that money actually can be used for their benefit rather than for some sort of problem or to their detriment. So our fifth and final celebrity we're going to be talking about today is a famous actor. Many of you know him from The Sopranos. James Gandolfini plays Tony Soprano. But James Gandolfini, he died unexpectedly in 2013, and when he did, he left a pretty sizable estate, $70 million, roughly, give or take, to beneficiaries, and many of them got it outright. But the problem was that he didn't factor in taxes. So in 2013, the estate tax exemption was a little over $5 million per head, meaning that if you were married, you can get about $10.5 million estate tax exemption, meaning that if your estate is under that threshold, then, it's not taxable by the IRS. But if it's over that amount, then you're going to be paying estate taxes on that. What can we take away from this? Well, there are ways to reduce this kind of tax hit, right? If he had a trust, I don't think it accounted for the amount that his estate was worth. He could have used gifting strategies, irrevocable trusts, portability, where one spouse can use the deceased spouse exemption later on. But that didn't happen. So it turns out James Gandolfini, not utilizing any of these major tax planning strategies in estate planning, made the IRS one of his biggest beneficiaries, something I don't think anybody really wants to do, something that people try to plan around. But that's the thing about these celebrities, right? You could be rich and famous, but everybody has an estate, and estate planning applies to everybody because nobody lives forever. So we've talked about 5 different celebrities and their estate plans. What's our takeaway from this? Well, first, have an estate plan. Step 2, make sure your estate plan is updated. Make sure that it aligns with what your current wishes are and that your beneficiaries are current, up to date. Number 3, make sure that we avoid ambiguous language in estate plan, especially for something as important as intellectual property. Another thing to always consider is your beneficiaries, right? Sometimes you don't just want to give outright to a beneficiary. Maybe they have special needs and you want to put it into a special needs trust to not disqualify them. Another consideration is tax planning. You want to make sure that your assets are preserved to the best they can, making sure all of that maximizes the value of your estate, maximizes what your beneficiaries are going to receive. So again, I'm Ian Wu at Goyette, Ruano, and Thompson. I work in the estate planning department. Please give us a call if you have any questions or want a consultation. You can go to our website. It's in our link. And as always, stay safe, stay protected, and you can do so by staying prepared.